For judgment, item number 1.
Petition is allowed. Respondents 1 and 2 are directed to place the respondent 3 junior to the writ petitioner in the post of general manager.
May it please your lordship, my lord.
Yes.
I'm sorry, my lord, I could not be present today. As I said, because I'm not so well, because my back, I have some problems. So I requested my learned friend yesterday itself, so if can be adjourned. And after vacation, my lord, it will be kind enough. If it is after vacation, my lord. I requested my learned friend also yesterday. So he suggested a date 5th of August. That will be a Tuesday.
Item 2, I think, well.
Item 2, my lord. Item 2.
Okay, okay. It's a fixed matter otherwise.
Yes, yes. I'm extremely sorry, my lord. It is 5th of August, my lord, if it is not
You got
inconvenient.
Instructions also? Have you also got instructions?
No, but very necessary for now. Yes.
On the prayer of the learned counsel, learned senior counsel, Mr. D. Das, the matter is adjourned to 5th August. The learned PP has no objections. On the next date, the learned PP shall obtain necessary instructions and scan copies of CD will be required.
May
It's
not-
up to you.
Oh,
Necessary instructions.
Yes, yes.
Fix
Yeah.
5th August.
I'm extremely sorry, my lord, for the inconvenience.
No.
So deeply obliged. Deeply obliged.
May I please, my lord. My lady, I would like to mention for item number 8 to 20. If the matter can be taken up after the vacation and as per the last order, trustee service was,
Done.
or yes, we have filed it, we have filed the affidavit on 19/6/2025. The affidavit,
The service for respondents.
respondent number, the UGC, respondent number,
UGC
yes, 10,
10.
yes.
Oh, that was in a particular case, I think.
Yes, WBC number 188,
88.
188 of 2023.
Learned counsel for the petitioner. Praise for listing the matters. This is 8 to
8 to 20.
8 to 20.
Item number 8 to 20.
After the summer vacation. Stop prayer is allowed. It is also submitted that the trustee service on respondent number 10 in WPC 188 of 2023 has been served and the affidavit to that effect has been filed.
On 19/6/2025.
2025. Stop. Learned counsel for the respondents. Such and such. Just record their names, okay? I think there are 2, 3 of them. Have no objection. This is the matter after this summer vacations.
Maybe a fixed date on 22nd of July, if my lady, please.
Okay. 22nd July.
Highly obliged.
May I please, my lady?
Yes.
I beg to mention item number 7.
7.
Item number 7. I may be granted 3 weeks' time to get further instruction. I got some instruction, but I need a further instruction, so 3 weeks' time may be granted to me.
Learned counsel for the respondent number
2 to 5.
Ms. V. Shukri prays for how much time?
3 weeks.
3 weeks' time to receive further instructions in the matter. Stop. Prayers allowed. Learned counsel Mr. N. Angami appearing for respondent number 1 is also present. The petitioner is not present when the matter is called. Stop. List after 3 weeks.
Much better.
I beg your pardon, my lady.
Yes.
There's interim in WBC number 340.
Okay,
May that be continued.
that list,
340 of 2023.
340, the interim order passed in WPC 340 of 2023 shall be extended till the next date.
Highly obliged, miss.
Ma'am, please, my lord. My lord, I beg to mention hearing item number 32. My lord, with a consensus brave from both parties, if this matter could be come up after 3 weeks, my lord. after summer break.
32.
32, my lord, hearing item number.
Learned counsel for the petitioner who has prayed for listing the matter after the summer vacation. The learned government advocate has no objections. List the matter after summer vacation for hearing.
Oblige me.
Lordship, I beg to mention item number 21, Lordship, on behalf of S. Mary. If this matter can come out after vacation, Lordship. 21.
Item 21, petitioner is there. Item 21.
Yes, your lordship. Lordship, there is an interim order that may kindly be continued, your lordship. Otherwise, we have no objections, your lordship. And if I pray, your lordship, the matter may be taken up on 5th of August, your lordship, if possible.
Fifth
And
of-
since the item numbers 22 and 23 are also connected, arising out of different FIRs, although I pray that all the three matters may be fixed on 5th of August, your lordship, if
21.
convenient.
21.
Yeah.
Learned PP has prayed for adjournment. On what ground?
She has
Lordship, there is a personal difficulty also.
He has some personal difficulties today. Stop. Learned counsel for the petitioner has no objections. However, it is prayed that the criminal petition 33 of 24 and 34 of 24 being connected matters may be listed together. So list the matter on 5th August 2025.
In item number 21, there is an interim order, your lordship, that may kindly be continued.
The interim order passed earlier in criminal petition 32 of 2024 may be extended till the next date.
May I please, your lordship? Lordship, I beg to mention item number 28.
Yes.
Yes. My senior has some personal difficulty today, so kindly this is matter on 5th August.
Learned counsel for the petitioner who submits that the leading counsel, Mr. P.J. Saikia, has some difficulties today and accordingly prays for listing the matter on 5th August. Learned counsel for the respondent number 2, Mr. Limawapang, and learned BP, we Zimomi have no objections, list on the 5th August.
Lordship, there is interim.
The interim order passed earlier shall continue till the next date. Yes.
May I please, your lordship. Lordship, I beg to mention hearing item 34, lordship. On behalf of M. Longkumar, lordship. Lordship, he is in disposal. Lordship, may please list the matter after vacation. I have taken the concern.
Governor Advocate V. Zimomi, who prays on behalf of Mr. M. Longkumar to list the matter after the summer vacation as Mr. M. Longkumar is indisposed today. Learned counsel for the petitioner, Mr. Wati Jamil has no objection. List the matter after the summer vacation.
Lordship, there is an interim order.
The interim order passed earlier shall continue till the next date.
Oblige.
May I please, your lordship? Lordship, I beg to mention item number 31 on behalf of S. Mary, Lordship.
Yes.
If this matter can come up after vacation, Lordship.
No objection,
On the
lordship.
prayer of learned counsel for the state respondents, list the matter after the summer vacation. Learned counsel for petitioner, Mr. Medo Vera is present and has no objections.
Lordship, there's an interim, lordship.
The interim order passed earlier shall be extended till the next date.
Much obliged,
Oblige,
Lordship.
lord.
Please, your lordship. I beg to mention item number 6. Leading counsel has some personal difficulties. Kindly grant 3 weeks to file affidavit in reply.
Lordship, in this matter, lordship, we have filed an IA to vacate the order that was passed on 2022 or 2023, lordship, by this honorable court, lordship.
Have you served copy?
Lordship. Lordship,
Have
in the
you-
course of the day.
Have you received a copy of the IA?
Lordship, I will serve in the course.
But we have not received a copy.
Let the matter reach then.
Lordship,
We'll pass necessary order when
Lordship.
it comes. Just wait for something. Yes.
May I please, your lordship? Lordship, I beg to mention item number 33.
Lordship, item number 33, it's been listed for hearing. However, your Lordship, if you may please, I may be allowed to file the affidavit in reply, Lordship.
Affidavit in reply.
Yes, Lordship.
You are for petitioner.
Yes, Lordship.
Heard learned counsel for the petitioner, Mr. Such,
Tapayakap
your-
Panyak.
who has prayed for some time to file an affidavit in reply to the affidavit in opposition filed by the respondents. Prayer is allowed. This is the matter after the summer vacation, before which date the counsel for the petitioner shall file his affidavit in reply. Learned government advocate and you are for
Respondent number 9 and 10.
counsel for the respondent number 9 and 10 have no objection. List after summer vacation.
Much obliged.
May I please, your ladyship? I beg to mention item number 25. Ladyship, we have only recently filed a Vakalatnama for respondents 2, 3, and 4. Therefore, if your ladyship may kindly grant us 3 weeks time to file our counter.
For respondent number
2, 3, and 4.
Learned counsel, Miss
Timsi Jamir.
Jamir, submits that she has received instructions to appear on behalf of the respondents number 2, 3, and 4, and accordingly requires some time to file the affidavit in opposition.
Please, your ladyship, if my senior's name may be reflected on the cost list, it's not reflected.
Oh, the name
Mr. S. Timjan.
is
Timjan.
Tamjan. MS such and such has prayed that the name of her senior, Mr. S. Tamjan, may be reflected in the cost list. Stop the registry is directed to do the needful. Stop. Accordingly, you have, did I say about the affidavit in opposition? To file a
File contracts.
How much time?
3 weeks time, your ladyship.
Accordingly, list the matter after 3 weeks. And then also for the petitioner has no objection.
Yes, Your Lordship, I'm appearing from Anula on behalf of Anula LKR.
Just put your name and say it's appearing on behalf of Anumla Lampumer has no objections. Yes.
Much obliged, your lordship.
May I please, my lord. My lord, I beg to mention item number or from the order list 24, my lord. I'll be accepting notice on behalf for all the respondents, my lord. From the order list, my lord.
So you need time.
Yes, my lord.
Learned counsel, such and such submits that he will be entering appearance for all the respondents and accordingly prays for some, you have filed your Vakla Nama.
No, my lord.
And prays for some time to file his Vakla Nama and the affidavit in opposition. So prayer is allowed. The learned counsel for the petitioner, Mr. Ajam is present. Is the matter after
4 weeks.
4 weeks. So
Obliged. Obliged.
For admission, item number. Sorry, I beg your pardon. For motion, item number 4. Item number 3.
Please, your lordship, am I audible?
yes. Item 3.
May it please your lordship, I appear on behalf of the petitioner today, Abhimanyu Kumar of Ma Kalyani Forest Produce Trading Depot, where an interim anticipatory bail has been referred. At the outset, I seek your lordship's kind permission for the perusal of the FIR 23 of 25. This is an Annexure A. It's on page 11, your lordship.
Yes.
The FIR reads that on the 19th/5/2025, an FIR was lodged by one Heto Yepto alleging inter alia that the FIR named arrested accused person, namely Pradeep Singh, is a staff member of Messrs. Heto Yepto Enterprise who works under the informant. The informant is also a businessman running Heto Yepto Enterprises. The parties got close with each other as they started working closely, and hence, in good faith, the informant entrusted the arrested accused person for supplying timber woods to another state, that is Assam. The accused, arrested, and the informant were working together since 2016, and since then, the informant started supplying the accused regularly with the goods. It was further alleged that on 18/01/2024, 7/03/2024, and 10/04/2024, the informant had paid the arrested accused rupees 38,000, rupees 12,000, and rupees 9,000 in cash, as the accused was in desperate need of money, and the informant, having good faith, even helped him in times of crisis. That the arrested accused person initially used to buy timber woods from the informant by way of credit. On many occasions, the arrested accused has bought bulk of goods and pay accordingly to the sales. However, since 2024, it was alleged that the arrested accused person has stopped paying the total outstanding amount of 15 lakhs 67,630 rupees, only from Messrs. Ma Kalyani Forest Produce Trading Depot, Vishnath Sarali, rupees 2,46,974 from Messrs. MK Timbers Trading Depot, and Messrs. Roy Timber Shop, Morigao, which is amounting to 3,664 rupees, and an amount of 4,14,475 rupees from Messrs. Santi Timbers, and from Messrs. MS Ali Timber Shop of Nolbari, amounting to rupees 2,96,475 rupees. It was also alleged that the payment was delayed and has not been paid till date, and moreover, the arrested accused has stopped responding to my calls and texts. The informant further said that since the year 2024, the arrested accused person has been making false promises to pay back the aforementioned outstanding amount, but to utter failure, he has absconded to different states. It was moreover alleged that the arrested accused person, he has been trying to abscond from the liability, which is becoming counterproductive towards the informant's business venture and his financial status. I would like to mention, Your Lordship.
Your name is not Pradeep Singh. The FIR is not lodged against you.
No, this is against my client Abhimanyu Kumar, who is the petitioner. He is not an accused person, my lord.
Yes, he's not an accused person. Yes. And
so now I'd like to come to the pardon, Your Lordship.
Yes, he is not an accused person, and he is not named in the FIR also. So where is the intention?
So what has happened is that a notice has been sent to him by the police.
Okay, okay. Where is the notice?
So that is in Annexure C, my lord. It's in Annexure C, my lord. That's page number 19.
The bills of it's taken from the arrested person. Okay, we'll issue notice. Let the PP obtain the case diary. Yes, who's appearing? Heard learned counsel for the petitioner. Miss, your name?
I'm Miss S. Kalita, Your Lordship.
Can you just spell it? Can you just spell it?
It's S-K-A-L-I-A.
This is an application under Section 482 BNSS spring for grant of pre-arrest bail to the petitioner. Stop. The learned counsel for the petitioner submits that an FIR had been lodged against one Mr. Pradeep Singh in the suburban police station, with FIR number 023/25, dated 19/5/2025, under section 318, under section 318 clause 4, 316 clause 5/61 clause 2 of the BNS 2023. So, it is submitted that in connection with the said investigation, he has been served a notice under section 35 clause 3 of the BNSS, and therefore he is apprehending arrest. Stop. Learned PP, Mr. V. Jimomi, has accepted notice on behalf of the state respondents. Issue notice returnable within how much time? 1 week.
Lordship, after vacation, since vacation is coming.
It has to be
It's a
after,
limited prayer, my lordship.
yes.
14.
But my lordship, if I may please, that would be infructuous because, as we know, the court's going into vacation.
There's some interim.
Just a limited prayer, my lordship.
So
It is just to keep him safeguarded, your lordship.
fixing should notice returnable on 16th.
16.
On 16 July. 2020. July.
It's a Wednesday.
Oh, yes, it's a Wednesday. 17th. 17th, on 17th July 2025. Stop. In the interim, it is directed that the petitioner shall be released on executing a bail bond of rupees 30,000 in the event of arrest, to the satisfaction of the arresting authority. So, and the petitioner shall also appear before the IO and record his statement before the next date. So it was made clear that this interim order is subject to the outcome of the case after the final hearing. Stop. The learned PP shall also obtain scanned copies of the case diary on the next date.
Lord. Obliged.
Much obliged, your lordship.
For motion, item number 4.
May I please, your lordship.
Yes.
Your lordship, here, the present interlocutory application is filed for impleadment of Sri Wanglei Konyak NCS Deputy Commissioner Mon as respondent number 6, your lordship, in contempt petition number 33/2024, your lordship. Earlier, it was Ajit Kumar Verma. However, Sri Wanglei Konyak, who has succeeded Sri Ajit Kumar Verma, your lordship. Therefore, it is necessary to implead Sri Wanglei Konyak as respondent number 6, your lordship.
This present application has been filed for impleadment of Mr. Wenye Konyak NCS as the respondent number
6, your lordship.
6. Stop. It is submitted by the learned counsel for the petitioner, Ms. Such and such, that the earlier incumbent, who was the Deputy Commissioner of MON, Mr. Ajit Kumar Verma, the respondent number 4, has since been transferred out, and accordingly, the new DC of MON, Nagaland, needs to be implemented as a necessary party as respondent number 6. Stop. The application is allowed. Stop. The petitioner shall file the amended copy of the cause title, and thereafter take steps for notice upon the newly impleted respondent number 6 by a registered post with AD, as well as usual process list after 4 weeks.
Obliged, my lord.
For 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50, 51, 52, 53, 54, 55, 56, 57, 58, 59, 60, 61, 62, 63, 64, 65, 66, 67, 68, 69, 70, 71, 72, 73, 74, 75, 76, 77, 78, 79, 80, 81, 82, 83, 84, 85, 86, 87, 88, 89, 90, 91, 92, 93, 94, 95, 96, 97, 98, 99, 100, 101, 102, 103, 104, 105, 106, 107, 108, 109, 110, 111, 112, 113, 114, 115, 116, 117, 118, 119, 120, 121, 1 For motion, item number 5.
Please, Lordship. Lordship, this is an application under Section 5 of the Indian Limitation Act, praying for condition of 79 days delay, Your Lordship. Lordship.
Third Learned Counsel for the appellant, Mr. Medu Vero. Stop. This is an application under section, this is IA, okay? IA 100. This is an application under Section 5 of the Indian Limitation Act, praying for condoning the delay of 79 days in preferring the accompanying MSc appeal. Stop. Issue notice to the respondents number. Yes, state is also a party.
Respondent number 11, and Home Commissioner.
Yes.
Issue notice to the respondents number. 1 to 10.
1 to 10, yes. Lordship.
1 to 10. Returnable within 4 weeks. Stop. The learned senior government advocate, Mr. K. Angami, accepts notice on behalf of respondent number 11. And no formal notice is called for. Stop. The appellant shall take steps for notice on the respondents number 1 to 10 by registered post with AD as well as usual process within 3 working days. We have received copy, no?
I've received what one if it may be
Lordship.
The petitioner is directed to, the appellant is directed to supply an extra copy of the petition to the learned government advocate.
Lordship. Lordship, in this case, the respondent number 2 to respondent number 9 is being represented by respondent number 1. So if that can be recorded, Lordship.
Oh, acha.
Yes.
It is also submitted that respondent number 2 to 9
Yes.
are being represented by respondent number 1.
Yes. Okay.
Please after forwards.
Much obliged, Lordship.
For motion, item number 6.
May I please the Lordship? Lordship, the instant IA 102 has been filed by the state respondent, Lordship, to vacate the stay order dated 2023 passed by this honorable court, Lordship. Lordship, because of the stay of this NOC dated 19/1/2022, which was issued by the chairman, and the MOU that was signed on 9/8/2022. Now, because of the stay of this 2 NOC as well as the MOU, Lordship, now the developmental work for setting up the petrol pump outlet at Dimapur Central Jail, which was kept on hold, Lordship. And that has caused because of this stay, Lordship, now the government could not continue the work, Lordship. And that has caused a huge loss to the state government, Lordship. Therefore, Lordship, the instant IA has been filed to vacate the interim order that was passed on 22/2023, Lordship.
You've
Lordship,
received copy.
Lordship, I have just served the copy, Lordship.
We'll have to fix a date for hearing.
Lordship.
It has to be on the opening day, I think.
Lordship.
Otherwise.
Lordship, here is the case where the petitioner, they are claiming for compensation, Lordship. But in fact, Lordship, even as far as land ownership is concerned, they are not disputing to that, Lordship. The land itself belongs to the government, Lordship, from the very beginning, from the ab initio, Lordship. And that is not been disputed.
IA is to be heard.
Lordship.
This is an application praying for vacation of the interim order dated 22/2023 passed by this court. The learned counsel for the petitioner has accepted notice and hence no formal notice needs to be issued. Stop. This the IA for hearing on 14/7/2025, along with the main writ petition. 14 of 2023. Otherwise, main writ petition is at what stage?
Lordship, it is in admission stage, Lordship.
Admission stage.
Lordship, in fact, all the parties have filed an affidavit, Lordship.
Hmm.
Lordship, to that effect, they were supposed to file a reply, but
Not-
till that,
They
they have not filed any reply. So because of that, we have filed an.
Okay, then along with the main WBC on 14th.
I look like.
Lordship, kindly record our presence, Lordship.
Oh, okay, okay.
Lordship. Lordship, I'm, since they are appearing to
Yes,
VC,
no, your junior is here.
Lordship, for the,
I'm for
And for the
the
respondent,
private.
I was saying,
Oh, okay. Mr. C.D. Romson is present for the respondent number
9 and 10.
9 and 10.
Mr. N. Bora for respondent number 8, my lord.
And Mr. N. Bora for respondent number 8 are present.
Obliged.
Blush.
For hearing, item number 26.
Lordship, leading counsel is in court one, motion matter. It will take around 15 minutes.
Okay, we can call later.
Okay, Lordship. This is a very small material, Lordship. And
Let's see. Where did Koza disappear?
he is already there.
Oh, okay. You ready?
Pardon me, Lordship, I was
Yes.
in court one. In fact, I was waiting for my turn for motion. But it's due, but
It has reached.
not yet. After two more items, it's in item number 4. But anyways, my colleague has already been appointed to court one. Maybe I'll continue with this case here.
Okay.
Yes, Lordship. Lordship,
Yeah, please, lordship. I'm sorry for the indulgence, your lordship. But in that item number 5 for that motion, that MEC,
Huh.
respondent number 2, 3, 4, 5, 6, and 7, till 7 is represented by respondent number 1. Yes,
Oh, not till 9.
not till 9.
Okay.
My sincere apology, lordship.
That other case, oh,
Yes.
I think Avunio took it down, yeah. So that will be respondent number 2 to
7.
7 are represented by respondent number
Yes,
1,
yes,
not respondent number 2 to 9.
yes,
Earlier we said 2 to 9,
yes.
it should be 2 to 7.
Obliged, lordship.
Lordship, here I am aggrieved because of the failure to exercise the jurisdiction by the revenue court, who is the TCT Mapur. Also for erroneous transfer to civil court.
Hmm.
Now, Lordship, this is the third round of litigation. Earlier, a writ petition was filed by the private respondents challenging the order passed by the revenue court in revenue case number 13/80D. Now, while hearing the matter, this honorable court, learned civil judge, has made an observation that the dispute concerns title. Therefore, the parties have to approach the appropriate civil court. Now, after passing the order, I have challenged the said order before the larger bench, the division bench, and the division bench has thoroughly examined and re-modified the order of the learned single judge. Thereby, Lordship, the division bench has made an observation that although the revenue court has made an observation on section 6C, that is with regards to adverse possession, Assam Land Revenue Regulation 1886. Now, that part has already been overshadowed in my case, admittedly, because while at the time of possession, I have to claim for adverse possession, that's clear. Law is clear on that. That is after 12 years. Now I've already been dispossessed from the property. So I do not no longer wish to pursue with that. However, there are other grounds, issues raised before the revenue court. That is as per section 50 and 52. That is regarding mutation, regularization, settlement of the patas.
there are a series of irregularities which I've already placed before the Revenue Court. Now, as per the statute, that is Regulation 1886, it is the Revenue Court itself who has to exercise the jurisdiction. There is power even on the civil courts. And that's very clear as per the regulation. So that part, without highlighting the checkered stories, Lordship, I would like to specifically rely on the jurisdiction. So, Lordship, kindly allow me to show the impugned order, that is impugned order dated 16 September 2022, Annexure E, page 49. Annexure E, page 49. Lordship, here in the order, the Revenue Court has made in this manner, if I may be allowed to read out, Lordship. The present case owes its genesis on an application having been filed by the petitioner's late mother under Section 6C, read with Section 53A, Clause 2, 54, and 151 of the Assam Land and Revenue Regulation 1886, hereinafter so and so, seeking inter alia for confirmation of right over the land acquired by law of prescription, cancellation of pata and eviction. Here, this is introductory part of the case. Now, the court below, as the DC Dimapur has only interfered with regard to Section 6C, leaving aside this Section 53, 54, and 151. 151, Lordship, here. There is no limitation. 151, Section 151 of the Assam Land Revenue Regulation prescribes no limitation. There is no limitation. There is no bar. However, without interfering to this part of the irregularities, the Revenue Court has only decided on adverse possession. Now, that is the reason why I'm aggrieved. Now, last part of this order, page 52, Lordship, if I may read out, in the light of the discussion made above, I hold that the Revenue Court does not have jurisdiction to adjudicate question pertaining to right and title based on adverse possession. Yes, adverse possession I'm not claiming anymore, but I'm only questioning the process of how mutation, settlement, and regularization has taken place.
So on that, there
No,
was
Lordship.
no finding.
Yes, no finding at all. Now, Lordship, if I may refer to the division bench judgment, page 41. Page 41, I'm taking to the relevant paragraph, Lordship, paragraph 14, page 41.
Page 41 is para 13.
Yes, Lordship, if I may read out. The caution inter alia, which was required to be decided by the Deputy Commissioner Dimapur, was the issuance of mutation and grant of pata in the name of the appellant over the portion of land over which they claim their ownership. Thereafter, making necessary correction in the name land record and evict the writ petitioners, private respondents from the portion of land. Although this portion is relevant, although the matter was heard at some length by Deputy Commissioner Dimapur, and although reports were called for in view of the preliminary objection raised by the opposite parties petitioners relating to the jurisdiction of the Revenue Court itself, the matter was referred to the government for effective decision and consequential instruction to the Office of Deputy Commissioner Dimapur was also sought for. This portion, Lordship, if I may clarify, I have already enclosed regarding the instruction sought by the Revenue Court before the government. That is at annexure number annexure F, page 53. Instruction was sought by the Revenue Court, that is DC Dimapur, and the government have clearly stated. Lordship, I'm jumping here and there, pardon me, Lordship. Now here in the forwarding letter, it's clearly stated in para 2, Law Department has examined the matter and it is to convey that the land issue are governed by Nagaland Land Requisition and Acquisition Act 1965, Nagaland Land and Revenue Regulation Act 2002, Assam Land and Revenue Regulation 1886, Nagaland Eviction of Person in Unauthorized Occupation of Public Land Act 1971, and Rules for Administration of Justice 1937. From all those laws, the Deputy Commissioner is invested with the power to handle and dispose land cases in whatever manner has already been complied with. So when these things has already been informed, instructed, and when these documents are here, DC Dimapur, without assuming its jurisdiction, is erroneously trying to transfer the matter to its civil court. Even otherwise, Lordship, the division bench has already observed that the parties, if aggrieved, may approach the civil court at any point of time.
Regarding right and title, that is okay, because revenue court cannot decide on that.
Yes, Lordship, but at least to the extent of settlement, mutation, grant of pata, the revenue court has its jurisdiction. And 151, Section 151 of the Assam Land Revenue Regulation states that there is no limitation, there is no bar on the revenue court to rectify, to correct. If I may read out
Because,
the relevant
we
portion.
have this Assam land revenue regulations, Assam land revenue regulations. So what is your prayer? To remand back?
Yes, Lordship, to rehear the matter on those issues.
What do you say? Can it be
Your
disposed of
Lordship.
with that direction?
Your Lordship will appreciate that. Section 5 of CPC, I beg to take your Lordship to Section 5 of CPC, Civil Procedure Code first.
Okay, CPC and then Assam land revenue.
CPC Section 5 is very much clear, your Lordship, that Revenue Code does not have any right or authority to deal with the matter, except where the question of rent or profit out of agricultural income. Besides this, Revenue Code cannot take up the matter. Now,
But mutation, grant of.
mutation, yes, I am coming to that, your Lordship. Mutation here, there are certain limit, your Lordship. This is not the first time, your Lordship. The petitioner has come before the Court of Deputy Commissioner under 6C of Assam Land Revenue Regulation Act. Earlier, and this is still continuing.
The same case.
The same case, and this is 2017 he came, or his mother came. Now, your Lordship, the main point is here. The land in question, it was regularized in the year 1977 in the name of Sosimongla Iyer. Then subsequently, Sosimongla Iyer, she subsequently sold it to Thongoimlong. Then Thongoimlong, I'm coming to that. Thongoimlong, no. Thongoimlong he sold it to that one Rongbai fellow and one Mugabe and the other 3-4 fellows. Then they sold it to this present appellant. But all at a sudden, while they entered into the land, this petitioner came with a piece of paper stating it earlier that this is his allotment. That Lomtisama GB, he has given one that affidavit that 50 company ASC army, he has given the land to the father of the present petitioner. Now, your Lordship, 50 company ASC, this does not have any right or authority to give the land to any person. Now, this is not the first time, your Lordship, 2017. Mutation started in 1977. And in 1992, he was evicted from the land. He was evicted from the land. This petitioner, he has not come before this honorable court earlier.
Civil Procedure Code.
Now, I beg to take your Lordship to 6C. 6C, there is limitation. It is a connecting one. His main case was based on 6C, your Lordship, of Assam Land Revenue Regulation. 6C.
Lordship, in that regards, I have authorities to place before.
Just, yes.
So if my submission may be heard first.
Okay, okay.
Then in that case, if you are not agreeing to that, then we'll have to go for a proper hearing.
Yes, Your Lordship.
Because that part submitted by senior counsel can only be heard before the trial court. And revenue itself is exercising as a trial court, although we do not have a board in Nagaland. Assam Land Revenue Regulation provides for a board, that is the appellate jurisdiction. Here in Nagaland, we do not have that. And this board was adopted only in the year 1976 by a notification that it will only have effective in Dimapur Mausas. But in a letter in spirit, it will be covered in all of the Nagaland state. That is all. Now, Lordship, this court, sorry, the larger bench has already made an observation. Now, in that regards, I would like to complete the remaining paragraphs, what this division bench has made an observation with. Now, paragraph 13, I have stopped at sought for. Now, if I may continue from there, Lordship. That is 1, 2, 3,
Consequential
4, 5.
instructions to the office of
Fifth
the
line from the
Commissioner
bottom.
was sought for, yes. Then
The core issue in respect of the claims made by the parties, namely mutation in respect of the appellant names over a portion of land which are mutated in the names of the private respondents have not yet been decided, Lordship, have not yet been decided. This dispute in respect of mutation was not gone into and effectively decided by Deputy Commissioner, although the respective parties filed their application an objection before the Deputy Commissioner urging their respective cases. Status quo was directed to be maintained by all parties till such time the matter is disposed of by the competent authority. While there is no dispute that pursuant to the judgment passed by the Court in Registrar General Gauhati High Court versus Union of India Supra, the Bengal, Agra, and Assam Civil Courts Act 1887 will be applicable to civil courts established by law and manned by judicial officers appointed under 2006 rules. However, it cannot be alongside of that the Deputy Commissioner Dimapur is one of the ex-officio revenue officer as provided under Section 123 of the Assam Land and Revenue Regulation 1886. Therefore, the question relating issuance grant of pata and/or cancellation thereof are questions which are to be dealt with by the revenue officer under the provision of the Assam Land Revenue and Regulation 1886, unless there are questions in respect of title, which can only be decided by civil court of competent jurisdiction. However, such finding to that effect is, at the first instance, is required to be arrived at by the Deputy Commissioner Dimapur in view of the issues raised by the parties in the application and which is presently pending disposal before the Deputy Commissioner Dimapur. The learned single judge, while arriving at a conclusion that the dispute regarding title are required to be decided by competent civil court, however, did not seek to interfere with the entire order dated 23/11/2017 passed by the Deputy Commissioner Dimapur. This is regarding status quo, Lordship, and or set aside the proceeding itself. Although specific prayers with regard to setting aside of the revenue proceeding was prayed for in the writ proceedings before the learned single judge, the learned single judge, while holding that the proper forum of respondent number 3, appellant, in respect of her grievances in the civil court, however, although allowed the writ petition by interfering with the order dated 23/11/2017 passed by the Deputy Commissioner Dimapur, only to the extent of the question of jurisdiction of Deputy Commissioner Dimapur in respect of the matter which was referred to the government for decision and directions. Status quo order passed by the Deputy Commissioner Dimapur was not allowed interfered with. Paragraph 14. Under the circumstances, this writ appeal is disposed of at this stage without any opinion on merits in respect of the interse claims of the parties by directing the Deputy Commissioner Dimapur to decide on the question pending before it in respect of the interse claims of the parties in terms of the provision of law, more particularly the Assam Land and Revenue Regulation 1886. Once the Deputy Commissioner Dimapur passes necessary order in the application pending, the persons aggrieved, if any, will have their statutory remedies under the Assam Land and Revenue Regulation 1886, or in the alternative, may seek their remedy before the civil court of competent jurisdiction as the case may. Para 15. Accordingly, this writ appeal is allowed and disposed of by modifying the order of the learned single judge to the extent indicated above and directing the Deputy Commissioner Timabo to decide the issue pending before it in respect of the intercede claims of parties in terms of provision of Assam Land Revenue Regulation. The decision to be taken by the Deputy Commissioner upon given due opportunity of hearing to the respective parties within 60 days from the date of furnish of the certified copy of this order by the parties.
So after this, you went to the DC? before
Yes,
this?
Lordship, and the hearing was conducted, and the outcome of the hearing is the impugned
This
order.
impugned order.
Yes. Now, if you looked at this impugned order, Lordship, the DC Timabur have never interfered with section 53, 54, and 151. That is regarding mutation, settlement, and regularization of the patas. But however, have only stressed upon section 6C, which is adverse possession, claim on adverse possession as per as Assam Land and Revenue Regulation 1886. This is specifically for adverse possession, where a person can claim adverse possession. Now I am admitting, Lordship, adverse possession can only be claimed when the person is in possession. Now I've already been dispossessed in the year 2009. How can I claim that? Although this specific prayer was also included in the complaint case, this is not the only issue I have raised before the revenue court. I have also raised on section 53, 54.
What is section 53 A2?
53 is regarding regularization, Lordship. Lordship, if I may take you to the relevant section, Assam Land Revenue Regulation. Fifty-three A2. Lordship, if I may read out, it is at page 141 if your Lordship is having the sample.
It's a different book. Anyway,
Okay,
I got
Lordship.
it.
Okay, Lordship.
53A2,
Two, yes.
where any person is aggrieved.
Yes, Lordship. Where any person is aggrieved by an order directing registration under this section, which has been made after verification of the information received by local inquiry only, he may, within a period of such and such, apply to the DC Dimapur to have such order set aside, and on receipt of such application, the Deputy Commissioner shall cancel the registration and then proceed to publish the notice and hold the inquiry prescribed by section 52 and 53 as if an application for registration had been received from person whose name had been registered. So this is the process where the DC Dimapur can recall to re-examine if there is any claim or grievances made by any of the person in respect to that any portion of the land. Now I'm questioning before the revenue court whether this notice has been issued or not, whether proper procedure has been conducted or not. This part have never been examined by revenue court, that is DC Dimapur, till date, Lordship, till the disposal of the impugned order.
And what is 54? 54, power to put one party in possession.
54, power to put one party in possession in case of dispute. If in the course of any inquiry made under section 53, a dispute regarding the fact of the possession arises and the Deputy Commissioner is unable to satisfy himself as to who is in possession, he shall assert in the summary inquiry who is the party best entitled to possession and shall put him in possession and make the necessary entry into proper register accordingly. So this is a subsequent procedure after following section 53A2. So this can only be done if the DC Dimapur hears the party in total in regards to Assam Land Revenue Regulation to 1886. And Lordship may also kindly see section 151. 151 talks about the power of the revenue court officer. Section 151.
Call for proceedings of subordinate officers.
Yes, Lordship. The board which we do not have, Lordship. A deputy commissioner, a settlement officer, and a survey officer may call for the proceeding held by an officer subordinate to it or him and pass such orders thereon as it or he thinks fit. So which says that, Lordship, the power of the deputy commissioner is not bound, it's not limited. I have a suggestion to satisfy this Lordship on this regard, regarding section 151 also. And if the opposite party, the respondent number 1 more particularly, says that this issue is pertains to title, Lordship, mutation only does not confer title. Mutation does not confer title to any person. Lordship, therefore, while exercising the jurisdiction of revenue court by the DC has failed to exercise its jurisdiction and rather erroneously tried to transfer the case to civil court. That is my grievances, Lordship. And the division bench has clearly stated that although hearing has been extensively made, the hearing was only made considering adverse position. But the DC have never examined on the section 53A clause 2 nor 54.
And what did the DC say about the survey report of 9/9/2022? Anything mentioned?
No mention, Lordship, no mention. In fact, there are certain irregularities shown in the survey report. This survey report was also conducted as per the direction of this honorable court only. However, they failed to examine this. Otherwise, Lordship, if I may read out that relevant portion, that 4th paragraph, we also checked the details of the patas in the Chita report, which has been issued in the area in contention, and found the following details. Shri so-and-so, Shri so-and-so, Shri so-and-so, pata number 1368, tag number 1425, area 1 Bika, 0 Kata, 02 Lashas. Original tag is number 11, is in partial occupation of the area in contention. Second, Shrimati so-and-so, pata number 1318, tag number 955/1, sir. Area 0 Pika, 3 Kata, 7 Lashas. Original tag is tag number 12, is in wrong occupation since the area in contention falls in tag number 11. Tag number 11 is the plot of land which is disputed in question. Shri number 3, Shri Amit Kumar so-and-so, pata number 1323, tag number 283/108, area 0 Pika, 1 Kata, 10 Lashas. Original tag number 7 is in wrong occupation since the area in contention falls in tag number 11. Number 4, Shri so-and-so, pata number 1322, tag number 108/1381, area 0 Pika, 1 Katas, 18 Lashas. Original tag number 7 is in wrong occupation since the area in contention falls in tag number 11. So all the plots, the patas issued are showing discrepancies, which demonstrates illegality in the process of mutation, settlement, and regularization, Lordship. It is very clear from the document, from the survey. And this was conducted as per the direction of this honorable court. However, at the time of hearing of the impugned order, this has never been considered or heard, and there's no whisper about the mention of this survey also. Worship, therefore, my humble submission is that the revenue court has been invested with the power to exercise such jurisdiction. So therefore, the revenue court, that is the Dimapur DC, should exercise as per the provisions stipulated in Assam Land Revenue Regulation 1886, which has been observed by the larger bench. More so, Section 151 does not bar the revenue jurisdiction to recall and to examine the discrepancies. Thirdly, Lordship, the issue examined by the Revenue Court in the impugned orders concerning Section 6C, which is an adverse position. To that aspect, I do not have any counter argument, but I rather admit to the fact that adverse position can only be claimed while in possession. I'm already dispossessed. I do not claim that any longer. Rather, I would pursue on the Section 53A, Clause 2 and 54, read with Section 151 of Assam Land Revenue Regulation 1886. Now, Lordship, I would like to place some citation regarding the mutation as well as the power of Assam Land, the power of the court, Revenue Court. Lordship, and one point is that the cause of action arose on 2009 when I was evicted, not dating back to 1977 when Sashi Matongla have obtained allotment of that portion of the land, that is 14 pikas. In fact, thereafter, when that was transferred to another person, Thongoy Imno, it increased to 19 pikas from the 14 pikas. There are so many discrepancies, but the main cause of action arose on 2009. Cause of action is very important, Lordship. That arose on 2009. Thereafter only, I have pursued, filed
In
multiple
2009,
RTIs. I was evicted from the
you
plot
were
of land.
evicted.
Yes, Lordship. In fact, that was also challenged, but I was made to withdraw the said case filed by one so-and-so Chakraborty. But that was withdrawn before being heard on pressure that too, Lordship. Anyways, those are the facts, checkered facts. Now I'm only confined to 4 katas of land only. That is it. But Lordship, in that sense, Lordship, I wish to submit, place some authorities concerning mutation, which says that mutation is only a process of name record, however, does not confers title to the parties. So in that sense, I mean to say that I am not contesting for title disputes. Rather, I wish to settle those unsettled issues, discrepancies which has arose and to which I have been dispossessed today. This is 2006 to Gauhati Law Reports 565.
You are, okay.
Equivalent citation is
Yes.
yes,
2006 to jailer.
JLR Lordship. Manmata Rajan Tripathi versus Gopal Krishna DE Go Private Limited and ORS. Lordship, I would refer to paragraph 14. Paragraph 14, if I may read, Lordship. Such an order affecting mutation in favor of a person prima facie shows possession over the land in question as per provision of Section 50 of Assam Land Revenue and Regulation 1886. In order to have a title over the land apart from the mutation, something more is necessary to claim title over the property, which may be by way of transfer in any form or by inheritance. a mutation order is passed to facilitate payment of land revenue, a chita mutation can be passed by following the procedure under Assam Land and Regulation. If any person having better rights or title objects such chita mutation, such person is entitled to challenge it before the competent revenue authority, and in that event, the authority is required to decide the matter on the basis of the rival claims between the respective claimants. So that is it, Lordship. So it means to say that mutation only does not confer title upon the person. So the present case at hand is not at all concerns to title disputes. Rather, a settlement has to be brought by the TC Dimapur regarding the discrepancies and illegalities which have occurred in the past transfers. Lordship, I also wish to place a citation to the other authority regarding limitation and power of the Assam Land Revenue Regulation. This is reported in 2009 5 GLR 468. 2009 5 Gauhati Law Report 468.
Yes.
Muhammad Ayaz Ali and other versus Muhammad Noor Islam Chaudhry and others. Lordship, here I would like to refer to two paragraphs, that is paragraph 8 and 10. 8 and 10. If I may read, Lordship.
Yes.
In Satya Rajan Baul Mojamdar Sopra, the full bench speaking through Baharul Islam judge further held as follows. The language of section 151 of the regulation shows that the power of the board is very wide and unrestricted. The board can sue Modopol for the records of a case and pass an appropriate order. The board also can pass an appropriate order on an application filed by an aggrieved party. That's very important. There is also no limitation for exercise of power under section 151 of the regulation. In my opinion, this is decision of the Supreme Court in ARR 1966 SC 893 Supra clinched the point. Now paragraph 10. In the light of the position of law as discussed above, we want turns to the fact of the present case. What becomes clear is that even if in the present case no appeal under section 147 had been preferred against the order dated so and so aforementioned passed by the settlement officer Karim Kanj, there was no restriction on the powers of the court to entertain an application against the said order in exercise of its power under section 151. And if the board finds on the basis of the reason which it shall have to assign that the order dated so and so is not sustainable, it can interfere with the order dated so and so aforementioned by invoking its jurisdiction under section 151. Since for the exercise of power under section 151, there is no period of limitation prescribed, the order dated so and so, which stands impugned in this writ petition and which has passed by the learned board decided to entertain the appeal cannot be said to be illegal and cannot be interfered with by taking resort to this court jurisdiction under Article 226 and or 227 of the Constitution of India. Therefore, Lordship, I have already stated in the earlier that in view of the absence of revenue board, the TC Dimapur have already sought instruction from the government of Nagaland, and the Department of Law has already communicated at Annexure F. At Annexure F, the type copy is at 54, that the TC Dimapur is invested with the power to handle and dispose land cases in whatever manner has already been informed and has been confirmed. Therefore, at this stage, DC Dimapur, assuming the revenue court cannot erroneously transfer the case to civil court without examining the issues at hand, and it cannot failed to exercise its jurisdiction as provided by the law. That is my case, Lordship.
And what are all these affidavits filed?
These affidavits have been filed by the government, government, respond number one.
No, you also filed, okay, reply. Affidavit
I have
number-
already filed my reply to this. Lordship, here in reply to respond number one, that is Deputy Commissioner,
Hmm.
I would like to stress paragraph 5, stress on paragraph 5 of my affidavit in reply.
Affidavit in reply to respondent 1,
Yes, my lord.
paragraph 5.
Paragraph 5. Shall I just give the paragraphs or
Yes,
do I have to
yes.
read out,
The
Lordship?
paragraphs only.
Okay, Lordship. Paragraph 5, 7, 8. 7, 8, then 12 and 13. That will be sufficient, Lordship. I've already stated. The contention of the respondent is very clear. That is trying to put limitation over me, that I have approached the court after a lapse of 12 years, 10 years. Those part I'm not contesting now anymore here, Lordship. I'm only considering with regards to mutation, regularization, and settlement. That has to be examined by the revenue court. Thereafter, the other affidavits are submitted by the private respondent number 3 to 8. To which I would like to say. Yes, Lordship, I would like to refer to paragraph affidavit in reply to respond number 3 to 8. If your Lordship has got it, I would like to highlight the paragraphs where I would like to refer.
Affidavit in reply to the 3, 4, 5, 6, 7, 8.
Yes, Lordship. Reply to respondent 3, 4, 5, 6, 7, 8. Yes, Lordship, I would like to refer to paragraph number 8, 9, 11, 12, and 14. Those are the paragraphs where I've refuted.
8, 9, 11, 14.
Yes, Lordship. 8, 9, 11, 12, 14. Otherwise, much has been stressed on facts, which is subject to consumption of the revenue code.
Yes.
That is the Lordship. Lordship, on 22nd March 2024, Lordship, the state respondent has filed affidavit in opposition, and more particularly mentioned in paragraph 4. Paragraph 4
Affidavit in opposition.
filed by respondent number 1,
R1.
R1. And we have categorically stated more particularly in paragraph 4, 5, 7, 8, 9, 11, 11, 12, Lordship. Lordship, as far as paragraph 4 is concerned, Lordship, if I'm allowed to read, Lordship. Page 2, page 2. That a statement made in paragraph 3 and 4 of the writ petition, the deponent denied in toto for want of jurisdiction by the Honorable High Court. In this connection, it is stated that the petitioner's occupation over the suit land is a disputed question of facts, which can be determined only by the civil court after leading unrebutted evidences. For that matter, the purported documents permitting the petitioner's late father to occupy the suit land by 50 Army Service Corps supply and the documents affirming the same by the then GB led Lomti Sema in the year 1965 has not been annexed to this present writ petition, and as such, it can be construed as an oral evidence that requires cogent evidence to prove the same. Lordship may kindly come to the affidavit in reply to the affidavit in reply filed by the petitioner, Lordship. To the affidavit in reply.
Affidavit in reply to the government affidavit.
Lordship, affidavit in reply, page 3, Lordship. If I'm allowed to read, Lordship. That a statement made in paragraph 8 of the affidavit in opposition are denied as it is misleading without any substantial documents. In this regard, the answering deponent states that the DC Dimapur on dated so-and-so has clear stated in his letter to the Principal Secretary and Commissioner Government of Nagaland that quote, this is to mention that the area of the land in question as claimed by Srimati so-and-so was under her occupation till 2025, unquote. However, it is humbly submitted that at this stage, very important, Lordship, at this stage, it is impossible on the
You're
part.
reading from the affidavit in reply of the petitioner.
Lordship, affidavit in reply filed on behalf of petitioner against
the affidavit in the position of respondent 1.
Lordship. Lordship, this is affidavit in reply filed on behalf of the petitioner against the affidavit in opposition of the respondent number 3, 4, 5, 6, 7, 8. Filed on 12 June 2024.
Yes.
Lordship, I'm-
Para
Paragraph, para 8, Lordship, page 3, para 8. If I may continue, Lordship.
yes.
That a statement made in paragraph 8 of the affidavit in opposition are denied, as it is misleading without any substantial documents. In this regard, the answering deponent states that the Deputy Commissioner Dimapur on dated 2016 has clearly stated in his letter to the Principal Secretary and Commissioner Government of Nagaland that quote, this is to mention that the area of the land in question as claimed by so-and-so was under her occupation till 2006, unquote. However, it is humbly submitted that at this stage, very important, Lordship, at this stage, it is impossible on the part of the petitioner to retrace and retrieve the affirmations so made by the then GB led Lomti Sema, since such affirmation/declaration was made orally during that period of time, Lordship. Lordship, even the petitioner is admitting to the fact that this was made orally, Lordship. And Lordship, they have only made a statement, Lordship. Lordship may kindly come to the page. That is just a mere statement, which is at page 20 of the writ petition, Lordship. The order, they have only annexed the order passed by the Deputy Commissioner to Muktima Lordship. And the relevant portion will be at page 20, Lordship, to whom it may concern, Lordship. As Lordship has got it,
Yes, to whom it may
Lordship.
concern. I, Shri, such and such.
Lordship.
Um,
So this is just an, they are also admitting to the fact that it is an oral Lordship. And Lordship, very important, Lordship may kindly come to the paragraph 7 of our affidavit, Lordship. Paragraph 5, page 3, Lordship. That was important, Lordship. If I'm allowed to read, Lordship.
Yes.
That with regard to the statement made in paragraph 5 of the writ petition, the deponent respectfully begs to state that the allotment bearing number so and so dated 15/10/1977 issued to so and so has not been challenged, Lordship, or set aside by a competent authority. Therefore, the said allotment order is now complete and it has attained finality. Further, the subsequent transfer made by so and so to so and so is not a subject matter, or that the subsequent transferee made a party to the present writ petition. As such, the deponent offers no comments, Lordship. Lordship may kindly come to paragraph 8, Lordship. Very important, Lordship. Paragraph 7, Lordship. Paragraph 7. That with regard to the statement made in paragraph 7 of the writ petition, the deponent begs to state that the present petition suffers from non-impleadment of the necessary parties, as stated in the preceding paragraphs. All subsequent transferee, other than the private respondents who are parties to the present petition, who were initial title holders of the land, has not been made a party to this present petition. As such, no such claim can be made against the unpresented parties. For that matter, it is to be seen that a title over the disputed land had devolved on the private respondents through various sale deeds, and unless this title documents and patas which had been held by the initial transferor are cancelled, no claim as to title can be made against the subsequent transferees. Be it noted that the jurisdiction for making such determination lies with the civil court. Further mention is made that a revenue court has no jurisdiction to determine title over a land under dispute or matters connected with adverse possession, Lordship. Lordship may kindly come to the
But
CPC,
they're also
Lordship.
saying that they are not claiming title.
Lordship may kindly come to the CPC, Lordship, like CPC, more particularly Section 5, Lord. Section 5.
Yes.
If I'm allowed to read, Section 5. Application of the court to revenue courts. 1. Where any revenue courts are governed by the provisions of this court in those matters of procedure and upon which any special enactment applicable to them is silent, the state government may, by notification in the official gazette, declare that any portion of those provisions which are not expressly made applicable by this court shall not apply to those courts, or shall only apply to them with such modification as the state government may prescribe. Now, two very important, Lordship. Revenue court. Revenue court in subsection 1 means a court having jurisdiction under any local law to entertain suits or other proceedings relating, now very important, Lordship, relating to rent, revenue, or profits of land used for agriculture purposes, but does not include a proceedings has been suits or proceedings of a civil nature, Lordship. Lordship, therefore, Lordship, while passing an order, Lordship, while passing an order by the Deputy Commissioner, the then Deputy Commissioner Dimapur, Lordship, it has been clearly mentioned, Lordship, more particularly at page 52, Lordship. Page 42, last second paragraph, Lordship, of the writ petition, Lordship.
Page 42.
Page 52, 52, Lordship. Order passed by the then
Yes,
Deputy
yes.
Commissioner. Second last paragraph. In the light of the decision made above, I hold that the Revenue Court does not have jurisdiction to educate question pertaining to right and title based on the adverse possession, and thus dismiss the application filed by the petitioner under section 6C of the ALRR 1886. I part with the observation, very important, I part with the observation that the issue being civil in nature, the petitioner may, if so desire, approach the competent civil court to address his claim, Lordship. Lordship, the Revenue Court has no jurisdiction at all, Lordship. Basing on the CPC section 5 Lordship, the Revenue Court has only jurisdiction with relate to rent, revenue, or profits of land, Lordship, used for agricultural purposes and not otherwise. So, Lordship, basing on this, Lordship, the order was passed by the then Deputy Commissioner, Dimapur, Lordship. And Lordship, here we have also stated in the paragraph 8 of our affidavit, Lordship, with regard to the eviction that was passed in the year 2009, Lordship. If I may allow to read, Lordship, of my affidavit in opposition. Lordship, they have approached the
Para 8.
para 8, Lordship. That with regard to the statement made in paragraph 8 of the writ petition, it is submitted that the eviction order dated 25/2009 has not been challenged by the petitioner in any proceedings before a competent authority, or that the same has not been quashed and set aside. This shows that the eviction order dated, eviction that was passed on 25/2009 has attained finality. Therefore, after a gap of nearly 13 years, the petitioner cannot make statement as regard its legality without complying following due process of law, Lordship.
Okay, I'll just come back.
Lordship.
Your basic case was 60. Basic case was 6. In fact, you were standard now. 53A, you were standard in the claim. That was also one of the prayer. The issue is even raised.
May I please your ladyship?
Yes.
Your ladyship kindly allowed me to mention for listing in COP 21 of 2024. As per this court order dated 26/2025,
Listed today.
it's supposed to be listed tomorrow. However, it's not listed. Therefore, if this matter may kindly be listed tomorrow. It's an urgency matter where new development has taken place and which needed to be placed before this court, your ladyship.
Was there a direction to place it tomorrow?
No,
was there
as
any-
per this order dated, it has to be listed after 1 week. So it falls tomorrow. However, it's not listed thereby. And more so, the conducting council are from Gauhati and they are already on the way, assuming that it would be listed tomorrow. Therefore, if this matter may be listed, kindly list it tomorrow. Much obliged.
Yes, please continue.
Lordship. Lordship, we have also mentioned, stated in the paragraph 8 with regard to the eviction, Lordship. Eviction order that was issued in 25/2009, Lordship. Lordship, the petitioner have not challenged the eviction order, Lordship. And after the gap of 13 years, Lordship, the petitioner is making a statement that it's legality, Lordship, and without following the due process of law, Lordship. That I have mentioned, we have mentioned in paragraph 8, Lordship. Lordship, may kindly come to paragraph 11, Lordship. Paragraph 11, Lordship. That the statement made in paragraph 11 of the writ petition is denied as afterthought, misleading, and concocted. In this connection, it is mentioned that while determining the issue brought before it, the respondent number 1 has no option but to confine himself to the pleadings of the parties. A perusal of the complaint petition filed by the petitioner's late mother before the respondent number 1, that is Deputy Commissioner Office, will reveal that she is praying for education of the case under section 6C of the ALRR 1886 for issue of pata to her, to set aside and cancel the pata held by the private respondents and thereafter issue of eviction. These prayers of the petitioner's late mother are nothing short of picturing a civil dispute. The jurisdictional court and not the revenue court. Attention is drawn on the aspect that dispute for determining title rights or ownership in land, eviction of person from private lands, and cancellation of pata, which is a natural corollary to the cancellation of the title documents, are all in the nature of civil dispute. Section 6C of the LALRR 1886 deals with the right over land based on limitation. As such, a reasoned and calculated decision was rendered by the respondent number 1 in its order dated, which I have already read out, 16/9/2022, Lordship. 12. The statement made in paragraph 12 of the writ petition are denied for the reason enumerated here below, Lordship. The petitioner led mother prayer in complainant petition filed before the court are as under, Lordship. Number 12A. A judge, petitioner applicant has acquired the right for prescription under section 6C of the Assam Land and Revenue Regulation 1886, and her name should be recorded in the revenue record. 12B, issue in her name a land pata passbook in respect of land measuring so-and-so, Moza number 2, and put her in the possession of the land. 12C, set aside and cancel pata so-and-so, block number, Moza number so-and-so. 12D, pass an order directing eviction of the respondents from the land in question with immediate effect. To that we have replied thereof to the statement made above. As regard to the sub-paragraph 12A, it is stated that the question relating to determination of the land on the basis of Section 6C of the ALRR 1886 lies with the civil court in Kanindra Hazarika versus Rekha Sakia reported in so-and-so. The Honorable Gauhati High Court has held as under Para 9, Regulation 6C of the Assam Land and Revenue Regulation 1886 deals with rights which may be acquired over land. No right of any description shall be deemed to have been or shall be acquired by any person over any land except, amongst others, right acquired under Section 26 and 27 of the Indian Limitation Act. Paragraph 19. It has rightly been held that for a decision or confirmation of right, title, and interest by way of adverse possession, it is only the civil court which is the competent to decide the issue and not the revenue court. Till such time, a valid title is counted on the petitioner, which he may obtain through a degree of the civil court. It will be inappropriate to delete the name of the respondents from the revenue records in respect of the land in question. The revenue court is not within its competency and jurisdiction to decide the issue relating to adverse possession and the effect of the provisions of Section 27 of the Limitation Act, which provides that at the determination of the period of limit as per the provisions of the Act to any person for instituting a suit for possession of any property, his right to such property shall be extinguished, Lordship. Paragraph 20. Various attending facts and circumstances will have to be addressed to before any declaration or right, title, and interest over a plot of land by way of adverse possession and or extinction of right to file a suit for right, title, and interest. The power to decide, very important, Lordship, the power to decide such issue is vested on the civil court, and the revenue court cannot usurp the power and the jurisdiction of civil court in the manner and method in which the same has been done in the instant case. The effect of the order passed by the revenue authorities is virtually the declaration of right, title, and interest of the petitioner of the land by way of adverse possession, which in my considered view is wholly without jurisdiction. As regard to the para 12B, it is stated that only after determination of adverse possession under Section 6C ALRR 1886 by the civil court as held by the Honorable Gauhati High Court in Kanindra Hazarika versus Rekha Sakia, reported so-and-so, can the petitioner claim for issue of pata, passbook, jamabandi, or any other consequential reliefs. As regard to sub-para 12C, it is stated that the private respondents were issued land, pata, passbook, jamabandi based on the title documents submitted before the respondent number 1 office, unless the title documents are cancelled by jurisdictional civil court, the pata passbook cannot be cancelled. It is reiterated herein that the cancellation in any title documents lies with the civil court, and the revenue court has no power for the same. For mention is made that once the sub-register duly registers a deed of conveyance, its genuinity cannot be called into question unless the same is set aside by a competent authority. Reference may be made by the judgment passed in Gunmal Jain versus GNCT of Delhi 2021 SCC Online Delhi so-and-so. As regard to sub-paragraph 12D, it is stated that the eviction order between the private individuals can be granted only after title is determined and established in favor of one party against the other. A person cannot be disposed unless the petitioner has established a better title and right over the land. Such procedures involve leading concrete evidence, proof of possession, documents, etc., and determination of facts is issued. Such powers are vested only with the civil court. Further, there is no provision under the Assam Land and Revenue Regulation 1886, which provides for eviction of any individual from a private property / non-governmental land under dispute. Thus, taking into consideration of the aforesaid facts and established position of law, a reasoned and a calculated order dated was passed by the respondent number 1, wherein it has categorically held that in the light discussion above, I hold that the revenue court does not have any jurisdiction to educate question pertaining to right and title based on adverse possession, and thus dismiss the application filed by the petitioner under section 6C of the ALRR 1886. I part with the observation that the issue being civil in nature, the petitioner, if so desire, approach the competent civil court to address his claim, Lordship. Lordship, may kindly come to paragraph 13, Lordship. I have said with regard to the documents to whom it may concern, Lordship. If I'm allowed to read, Lordship, that with regard to the statement made in paragraph 15 and 16 of the writ petition, it is admitted that a survey report was submitted by the DLRSO, right so and so, dated 8/9/2022. However, it is submitted that the survey report are revenue records, which does not form a document of title. Survey report are only limited to identifying of land for such legal purposes and is not conclusive proof of a title. In the case at hand, when a complainant petition was filed by the respondent number 1's office, a joint spot verification was directed to be carried out by the Honorable Court, and thereafter the survey report was submitted along with the map depicting the ground possession of the disputed land to which claim and counterclaims has been made by the petitioner's late mother and the private respondents. The survey report only mentioned as per the claim and not as quote, the land belonged to, or quote, land encroached by, unquote, apart from to whom it may concern, document purported to have been issued by late Lomti Sema. No other documents were produced by the petitioner to substantiate his claim over the disputed land. As regard to the other statement pertaining to the wrong occupation made by the private respondent, it is only after the petitioner establishes that he has a better title over them can the other consequential grievances be addressed with, as stated, the petitioner has no title documents but to whom it may concern certificate, and therefore assuming but not admitting the latter document can only be used for limited purpose of establishing adverse possession by the petitioner. Thus, by not referring to the survey report in the impugn order does not vitiate the decision rendered therein, Lordship. Lordship, so my humble prayer before Lordship is, there is no illegality whatsoever in passing the order that was passed by the then Deputy Commissioner Dimapur, order dated 16 September 2022, Lordship. And Lordship, since this is the disputed question of facts, Lordship, the matter has to be educated in the civil court and not by the revenue court, Lordship. That is my humble submission, Lord.
Then what happens to the order of the division bench, the direction of the division bench?
Lordship, the direction of the Honorable Division Bench, Lordship, may kindly come to page.
The division bench said clearly that that the DC can go into these matters, the issuance of mutation, grant of pata.
Lordship may appreciate, Lordship may kindly come to paragraph 14 also, Lordship, 14, page 42, Lordship, page 4, if I'm allowed to read, Lordship.
Yes.
Under the circumstances, this writ appeal is disposed of at this stage without any opinion on merit in respect of the inter se claims of the parties by directing the Deputy Commissioner Dimapur to decide on the question pending before it in respect of inter-se claims of the parties in terms of provision of law, more particularly the Assam Land Revenue Regulation 1886. Once the Deputy Commissioner Dimapur passes necessary orders in application pending the persons aggrieved, if any, will have the statutory remedies under the Assam Land and Revenue Regulation 1886, or in the, very important lordship, or in the alternative, may seek their remedy before the civil court of competent jurisdiction, as the case may be, lordship. Lordship, here the observation of this honorable court.
See, this court has had the occasion of sitting in the civil court also. So when in certain cases, the DC even cancels the pata and then they come before the civil court. Then what stops the DC from going into the issuance of pata in this case? The DC cannot say that he does not have the jurisdiction.
Lordship, if Lordship may appreciate, Lordship, as far as the CPC 5(2) is concerned, Lordship, if you go by this
No, I'm
Lordship,
not saying the DC can go into the title. DC cannot go into the title. But regarding the discrepancies in the pata and discrepancies in the mutation, DC can certainly go into those.
Lordship, but as far as
They themselves are saying that they are not claiming on the adverse possession because now they are out of possession.
Lordship.
They are already evicted. So that is not an issue anymore. So the DC can certainly go into the issue of if there are any errors, any discrepancies in the issuance of the pata, then certainly the DC can go into those. And if aggrieved, then the petitioner can go to the civil court. But here DC has just refused to enter into anything. DC has just said that he has no jurisdiction in it.
Lordship. In fact, the GC has now jurisdiction, Lordship, and basing on the Lordship.
Because if DC has no jurisdiction in that, then why should the division bench refer it back to the DC?
Basing on the
division bench will never refer it back. In fact, the division bench will tell them directly to go to the civil court. But the division bench has referred it because there is something which the DC can go into. Yes, anyway, yes.
Your Lordship, I am for 328. Your Lordship,
Who's for 7?
state 328. All the
There
private
is
testimony.
one affidavit on behalf of respondent number 7.
Oh, they have separately filed their affidavit, Your Lordship. So all the individuals, they have filed their separate. Now, Your Lordship,
This is 3, 4, 5, 6.
that might be replied.
You are for respondent?
3, 4, 5, 6, 7, 8. All the private testimony.
6, 7. Then why respondent number 7 has again filed a separate affidavit?
No, all the parties have filed their separate affidavit.
Separately.
Because Your Lordship,
But there is again common one on behalf of 3, 4, 5, 6, 7, 8. Common affidavit. Common affidavit is there, and then separate affidavit is also there.
I have filed a common affidavit in reply.
he
all
has
the-
filed a
yes.
common.
Oh, okay.
It is their affidavit in reply.
Okay. And yours, you have filed separately.
Separately for almost same, Your Lordship. But here, Your Lordship,
Yes.
the petitioner is claiming that he is having four lessons. But he has made party here 6, 3, 4, 5, 6, 7, 8. 6 respondents. 6 respondents are having the area of land more than 4 bighas. Now, Your Lordship, petitioner does not know where his land is. Undefined land. And I have stated therein. Now, Your Lordship, I'm not going to that because since 6C is not pressed, adverse possession is not pressed, I'm not going to that. Now, Your Lordship, here this question comes that the cancellation of registration. Section 53A of Assam Land Revenue Regulation. Now 53A and 54. Actually, Your Lordship, if Your Lordship kindly peruse their petition, if Your Lordship kindly peruse the petition, their relief was to cancel the patta, to put the possession, to evict. My learned friend has read out just now.
The petition before the DC.
Yes.
It is not enclosed in the.
They have not enclosed it. It is not enclosed. Not enclosed. Now, Your Lordship, that page 6 of the affidavit of government, the same thing has been reflected. The prayer.
In the pleadings, it is there. In the pleadings, it is there, but a copy is not here.
Yes.
So not annexed.
Not annexed. However, Your Lordship, the state government has, in their affidavit, they have stated what was the prayer of the
Para 12.
para 12. So I need to repeat para 12. Only adjust that petitioner applicant has acquired 6C, they have issue in our name land patta, set aside cancel patta, pass an order directing eviction. So these are the prayer in the application. So their prayer nowhere it says that to exercise power under 53A 2 of Assam Land Revenue Regulation. The petition does not refer that on. Application before DC does not have this prayer. Now, Your Lordship will appreciate that the petitioner is a stranger. Petitioner is a stranger, Your Lordship. Your Lordship, when the petitioner was evicted in the year 2009, and admittedly petitioner is not in possession of the land. And prior to that, Your Lordship, since 1977, while the land was regularized in favor of A, they did not lose their objection against regularization. Then subsequently it was transferred to B, mutation, then what it is called passbook issuance. They have not challenged this. Then third time also it was mutated. They have not challenged this. Then they were evicted. After that, they became silent. Then only in 2017, this petition was filed before the Deputy Commissioner. Now, Your Lordship, I beg to take your leadership that 53A.
2017, it was filed.
Yes, Your Lordship. The petition was filed in 2017. (23/6/2017). As per records. Petition. Now, Your Lordship, 53A, Assam Land Revenue Regulation. Power of Deputy Commissioner to direct registration on information received otherwise than through application. This is pertaining to registration of the sale deed. Sale deed or gift deed, whatever may be. Now, I will not recur to read this one. Now, I beg to take your Lordship to surplus 2. Where any person is aggrieved by an order directing registration under this section, which has been made after verification of the information received by local inquiry only, he may within a period of 3 years. There is a limitation, Your Lordship. Within a period of 3 years of the date of such order, apply to the Deputy Commissioner to have such order set aside, and on receipt of such application, the Deputy Commissioner shall cancel the registration and then proceed to publish the notice and hold the inquiry prescribed by section 52-53 as if an application for registration had been received from the person whose name had been registered. Now, Your Lordship, this cadastral land, transfer of cadastral land, there is procedure, Your Lordship, and in Assam Land Revenue Regulation, it prescribed how this land is being transferred, mutated, and registered. Now, in registered also, Your Lordship, Indian Registration Act is also applicable. There is also limitation, 6C since not been pressed, but section 27-28 Indian Limitation Act is applicable there. There is also time limit. Now, here is also time limit, Your Lordship. Now, whether this petition was made within a period of 3 years or not, this is a disputed question of facts. Now, whether a disputed question of facts can be decided by a revenue court without adducing evidence, Your Lordship. Now, there are katana of judgment wherein this honorable court and other court have also observed that the disputed question of facts and law, where evidence is required to be adduced, this can be decided by regular court. Regular court. I beg to take Your Lordship to that famous judgment of the Registrar General, 2013, volume 5, volume 4, page 1109. Wherein this honorable court has held that Your Lordship is well buzzed about this. I will not
that famous judgment.
I'll take only this last one, Your Lordship. 35. Your Lordship. And 34 and 33, 34, 33, 34, 35. 33. We further hold that CPC and CRPC are applicable to the regularly constituted civil and criminal courts without any manner affecting operation of Article 371A or the functioning of village customary or any other courts other than the regular constituted civil and criminal courts in the state of Nagaland meant by members of judicial service. Now, Your Lordship, in Dimapur, there is regular civil court. There is a regular civil court, Your Lordship, and this matter is not affecting this Article 371A. So since there is disputed question of facts and law, Your Lordship, so matter is to be adjudicated before a civil court, adducing evidence. Now, my learned friend has referred this Khonindo.
See, only because of the division bench judgment, they have gone before the DC, isn't it?
Yes, Your Lordship. But DC has adjudicated the matter, Your Lordship.
What you are saying is right. Limitation is a disputed question of facts.
Yes, Your Lordship.
But has the DC stated anywhere all these things? Nothing. DC has only said that regarding the adverse possession. Only that much.
Yes, and their prayer, Your Lordship will appreciate
So
that they are.
DC could have easily said we have entered into this and because of this dismiss. Or he could have entered into the adverse possession. Okay, fine. Adverse possession he entered into and he said that this cannot be decided. That's fine.
Yes.
But regarding this
cancellation.
and all that,
Now cancellation, Your Lordship.
yes.
Cancellation. Now here also limitation, question of limitation arises, Your Lordship. Now, what right he is having? A stranger, whether a stranger is having any right to.
When the order doesn't say anything, by way of affidavit, can you improve on that? The law is there already, that by way of affidavit, whatever the order says, that only has to be taken.
Yes,
So
Your
very well, yes.
Yes, Your Lordship. But now here, if it goes against to Deputy Commissioner, then it will be continuing, Your Lordship, one after another.
No. If
Same matter.
The DP has already said if aggrieved, he'll go to the civil court.
Now here, your lordship, this 53, when any person is aggrieved by an order. Now this person, who is a person, your lordship? Now here, whether he is having any right, when he is not claiming adverse possession, then what right he is having to challenge challenge my mutation before DC? Is not it illegal, your lordship, against the provision of article this 53A? Now 54 also says that, your lordship, who is in possession, DC,
one party in possession.
DC can take a decision on that, your lordship.
Section 54 is also there now.
Yes, your lordship. Power to put one party in possession in case of dispute. If in the course of an inquiry made under section 53, only inquiry it says that, your lordship, a dispute regarding the fact of possession arises and the deputy commissioner is unable to satisfy himself as to who is in possession, he shall ascertain by summary inquiry who is the party but best entitled to possession. Now, your lordship, this it does not affect me because I am in possession, and this petitioner, he's a stranger now. He is a stranger now, your lordship, and that his claim, anyway, your lordship, his claim, what is praying before the deputy commissioner. These are all mixed question of law and fact. He is claiming he is the owner of the land by virtue of a affidavit or something like that. But this is to be proved before DC cannot take what it is called evidence and prove those documents, your lordship. These can be proved by a regular court, your lordship. And the honorable division bench of this court has also held that.
See, the question which was required to be decided
My lord,
by the Deputy Commissioner Dimapur was the issuance of mutation grant of Batta in the name of the appellant over the portion of land over which they claim ownership, thereafter making necessary corrections in the land report and evict the writ petitioners private respondents from that portion of land. Although the matter was heard at some length by DC, and although reports were called for, in view of the preliminary objection raised by such and such, the matter was referred to the government and
it was earlier, your lordship, prior to division bench.
No. This is the division bench order. This dispute in respect of mutation was not gone into and effectively decided by the DC. Clearly stated by the DB. How can this court now go beyond this?
No, deputy commissioner has.
The DC has not entered into anything.
Deputy commissioner.
Whatever you are saying now, the
Yes.
DC should have said in his order.
Your lordship will appreciate that. Deputy commissioner has taken their petition.
Dismiss it, no problem. But he has not discussed anything. He has not come to a finding on any of the issues. Please agree with me. You also go through the order. DC has not gone into anything.
DC has gone that he is not having jurisdiction.
Only that much.
Jurisdiction.
He can always discuss each
Now-
point and say because of this, no jurisdiction. Because of this, no
Now your lordship will appreciate that. Revenue court cannot frame this issue and discuss.
No need to frame the issue. You can, like you said, now limitation is there. Now all those things, DC can always enter into that. Because the division bench has already stated that the DC should have gone into the mutation and all that. Whatever you're saying is all right. It is right. Yes, but I'm just on the deceased order. We'll dispose it, send it back. We'll give some directions saying that the DC should specifically discuss on this as directed by the division bench and issue appropriate orders.
My lord,
I think
no,
that's.
my lord, my lord,
Yes. Dispose, chamber dispose.
my lord, my lord.
Just call.
Because there is a long pending
No.
dispute, your lordship.
No pending dispute, but we cannot go beyond the division bench order. That's the problem.
People say this, let this.
Just send it to my chamber, okay? So, also.
The DC should pass a speaking order, your lordship.
Yes, that's why. That's why.
For hearing,
Chamber disposed. Yes.
item number 27.
Much of it.
Yes. Goes on.
Yes, my lordship.
Yes.
Lordship,
Is this
the
a long matter?
lordship, the matter pertains to regularization of petitioner service. Lordship, in this matter, the petitioner was initially appointed in the year 1993, and thereafter, in the year 1995, the petitioner was appointed as a bus conductor in work charge on his health pay. The petitioner was rendering his service for 32 years under the establishment. Lordship, it is a covered case as per the OM 17 March 2015. Where it is,
30 years.
yes, Lordship. He is
You
serving under the
consider?
Lordship, may kindly see page 19 of the writ petition. This is 17 March 2015 OM. It is very clear, it says, an employer who was enjoying a scale up pay and worked for more than 30 years can be regularized. That is 17 March 2015 OM. Petitioner has qualified that.
Yes.
We admit that. But now here, your lordship, page 19. Page 19. Lordship, you'll see page 19, para 3. Conditions for implementation of the scheme for regularization and revision of pay. Each department shall prepare detailed list of all such work charge and casual employees enjoying scale up pay who have completed 30 years or more service as on 1/1/2015 in most cases has been proposed for regularization indicating name, designation, date of birth, date of entry into service, date of retirement, pay scale, and existing total emoluments. Pay scale admissible on regularization, total emoluments of the regularization, and additional financial implications. Number two, the list shall be verified by the district level verification committee to the effect that the incumbents included in the list are verified and found genuine. Here, in the case at hand, your lordship, petitioner has failed to appear before the district level verification committee. So
He has been.
because this is a mandatory requirement to be verified by the district level verification committee. That I just read out in Baratu. So
No, we'll say that as per the conditions laid down in para 3, 1, and 2,
Yes, yes. Lordship, may can this by para 5 of the government affidavit? Para 5, page 2. Page 2, para 5. That with regard to the statement made in para 7 of the writ petition, the answering deponent respectfully states that the office memorandum dated 17 March 2015 issued by the Department of Personnel and Administrative Reforms, Nagaland, scheme for regularization and absorption of work charge and casual employees and revision of pay, which is, it is categorically stated in para 11A that the incumbent concerned and his or service rendered as a work charge casual employee have been duly verified and found genuine by the district level verification committee constituted by the government. However, the petitioner has unfortunately missed out to attend the district level verification committee. As such, his service could not be regularized due to absence of verification
Why
report.
did you attend the
Yeah, please, Your Lordship, do that. I find my affidavit in reply. Lordship, it is in bar 4. Yeah, with Lordship. With regard to this amendment in bar 5 of the affidavit in opposition, the answering deponent begs to state that the petitioner become eligible to be considered for regularization in the month of June 2023. That is the date when he attained 30 years length of service in terms of office memorandum dated 17/03/2015. It is respectfully stated that the district level verification committee constituted by the government in terms of the aforesaid office memorandum and did not give an opportunity to the petitioner to verify his service record, and hence that the statement the petitioner has unfortunately missed out to attend the verification process is totally denied. In fact, the petitioner is ready to appear before the district level verification committee. Lordship, here the petitioner was never called up for verification by the department. Lordship.
Then you give them an opportunity to appear before the, because if he's eligible, then you cannot deny him that right. Would dispose of it. This petition has been filed by the petitioner praying for regularization of his service in terms of the scheme of the government set out in the office memorandum number AR-3/GEN-201/2009 dated 17 March 2015. Stop. Next paragraph. I have heard learned counsel for the petitioner, Mr. Such and such. And the learned senior government advocate, Mr. Moa Inchin, for the state respondents. Next paragraph. The facts of the present petition is that the petitioner was appointed as a bus conductor by an order number HTE/COL-ESTT/13/83/652 dated 1/6/1993 under the establishment of Sao Chang College, Tuensang, Nagaland. Stop. Thereafter, by another order number HTE/ADMN-COL/15/95/280 dated 31/8/1995, the petitioner was temporarily appointed as bus conductor on work charge basis. The earlier was on fixed pay. Earlier was on a fixed pay. Then this one, the petitioner was temporarily appointed as bus conductor on work charge basis under the same establishment on scale pay. Stop. It is also stated that the petitioner has been rendering service for more than 31 years in the same capacity. Stop. It is also stated that the petitioner's case is fit to be considered for regularization in terms of the aforementioned policy of the state government dated 17/3/2015. Stop. Being aggrieved, the petitioner had made a representation on 12/7/2024 for regularization of his work charge service. Stop. However, the representation was not considered. Stop. Being aggrieved, the petitioner is before the court. Next bar. Learned government, senior government advocate Shri Mo Im Chen has fairly submitted that the petitioner is eligible to be considered for regularization under the OM dated 17 March 2015. However, he has submitted that in the OM dated 17/3/2015, there is a condition that each department has to prepare a detailed list of work charge and casual employees enjoying scale pay who have completed 30 years or more in service as on 1/1/2025. So, moreover, the condition 3, serial number 3, small 2, clause 2, specifically states that the list shall be certified by the district level verification committee to the effect that the incumbents included in the list are verified and found genuine. Stop. It is submitted that the petitioner did not attend the district level verification committee, and as such, his service could not be regularized due to the absence of the verification report. Stop. This statement is refuted by the writ petitioner by filing an affidavit in reply stating that he was never given an opportunity to appear before the district level verification committee. Stop. Next bar. In view of the facts and circumstances as stated above, comma, this petition is disposed of with the direction to the respondent's number. Respondent's number
Yeah, please, Your Lordship.
1, 2 is.
Lordship, as per the OM 2015, two, the verification should be taken in two phases. That is in 1st January.
In January and July.
July. So in next verification, it is going to be held on next month.
Can you do that? Can you put his name in the July verification?
No, that I can, Lordship.
In a year, they do it twice.
Lordship, because that is sending up the list. Now, district verification is usually done by the respective deputy commissioners. The department concerned
Okay,
should.
that we cannot
So
say.
that
We'll
is like
just give 4 months time.
Yes.
In 4 months time, and
Yes.
within that time, let them process. Okay. So with the direction to the respondents number 1, 2, 3, and 4 to send the name of the petitioner to the district. No.
To verify the name of the petitioner
Verify the name of the petitioner.
by the district level committee.
To get the name of the petitioner verified by the district level verification committee, comma, and before which the petitioner will be given, should be given a chance to get his documents verified by giving notice, proper notice.
District level verification committee.
By giving him proper notice. Stop. Thereafter,
Process for regularization.
the department concerned shall take up the process for regularization. Stop. The entire process is directed to be completed within 4 months from the date of this order.
May I please, Your Lordship?
Yes.
I have a limited prayer before this
Yes,
court.
yes.
The petitioner, he reached 30 years length of service on June 2023.
Ah.
So his service should be regularized. by
No,
any
they're also not disputing. They are saying that you're eligible.
Lordship.
Ah.
From the date he attended the 30 years of service.
No, that
That-
they know best.
that
what
will
to
be
do.
done, that will be
Yes,
done.
yes.
Mm.
As is done with other workshop employees, they are doing it
That will be done.
every year, so they will know how to do it. Yes. So, please, with these directions, the petition stands this.
Much obliged.
Obliged, Lordship. For hearing item numbers 29 and 30.
May I please, Your
Let's
Lordship?
hear this after vacation.
Oh, Your Lordship, it's a small
Because
matter.
I've got,
Minimum scale of pay.
Minimum scale of pay, my lord. Just short.
It's up
very
to the
short.
Lordship.
Yes, lordship, it's,
because I have to dictate these orders now.
okay, lordship, lordship.
After vacation. Okay.
Okay, okay.
See, the paucity of time is the matter after the. Minimum scale of pay meaning that.
Yeah, it will be covered.
You can dispose it
covered
of
by
the
this,
latest.
Acha, acha, the latest OM of
Yes.
March.
Yes, yes, yes.
Obliged.
Much obliged.
Vincent, Awe, Puko, Awele, Tushi, Molojit, anyone there? Court over. Court is over. Court 2.